Good morning, Mr. Thomas.
Good morning, my lady. Just before we broke yesterday, I was dealing with the bank's primary case as to why the bill of lading contains or evidence of the contract all along. I've taken the court to the Rodonacci decision.
Yes.
Just briefly going to address the other authorities which we say are contrary to the proposition and fully support our own position. The next authority was Tate and Lyle. That's in tab 4 of the authorities bundle, but it's cited in the judgment. It may be that sufficient to refer to the relevant paragraphs. Those are paragraphs 23, first of all, where the judge in our submission quite correctly said, clear on the authorities that where a bill of lading is issued to the charter and then endorsed to a third party, it attains contractual status upon endorsement on the basis that the new contract appears to spring up on the terms of the bill of lading. Of course, that's inconsistent with it being a contract all along, as the bank contends. So that's the reference to Tate and Lyle, which is marked up in the bundle. The second passage referring to this case is at paragraphs 38 and 39 of the judgment. Her Ladyship observed, referring in 37 to a footnote to that paragraph.
You've no doubt taken us to Tate and Lyle in the judgment rather than the case itself, because immediately following that passage, there's the statement that nothing that's done under the charter party can be a waiver of the bill of lading contract.
My Lord, yes, we'll come to the waiver issue in a different context later. We say that one has to look at that precisely what nothing done under the charter party can be a waiver, but that doesn't affect the position of BP as the bill of lading holders, which is where this issue arises. And that's one of the reasons. I'll come to it in more detail.
Yeah, we'll come to that in due course,
Yeah.
but that is something that's in that passage beyond that which was quoted in the judgment.
My Lord, of course, I'm dealing with ground one here, so I'm not seeking to avoid that. We'll come to that, but indeed, in that case, there's a waiver to the extent that the Charterers chose not to terminate the charter party due to the deviation. So there's a waiver of that particular right under the charter party, and it said that doesn't affect the bill of lading. We don't see a problem with that, but that's not the same as saying where the bill of lading holder, in this case BP, does something, that action is not binding on the subsequent holder. So it's a very different scenario, is what we will say about that case.
Right, but you're going to come to that. I didn't mean to take your...
No, my Lord, I appreciate that. I was trying to make sure that we have time to debate these issues later rather than solemnly going through everything in detail now. But in terms of those propositions, they're repeated in other cases. The Hooder talks about a bill of lading being a potential contract, but in our submission, the position is well summarised in the various textbook extracts, which Her Ladyship duly identified in the judgment as well. First of all, she identified and referred to two passages from Aitkins in the judgment at paragraphs 28 and 36. It may just be worth taking this out. It's tab 21 of the authorities bundle. And it may be just as well to start at paragraph 7.3, which is, if you like, the context of the remainder of the remarks. One of the most often quoted maxims concerning a bill of lading is that a bill of lading is not the contract, but only evidence of the contract. Or in the words of Goddard C.J. in the Ardennes, the bill of lading is not itself the contract between the ship owner and the shipper of goods. And then at 7.23, which is cited by the judge in paragraph 28 of the judgment, she notes an important exception to the rule. The bill of lading contains or evidences the contract of carriage is where the bill of lading is issued or endorsed to the charterer in respect of goods carried on board the chartered ship, at least where the carrier on the bill of lading is the same party as the owner for the purpose of the charter party. The bill has no contractual force and constitutes a receipt only in the hands of the charterer, the relevant contract of carriage being contained in the charter party. And the other passage which she cites in her judgment is over the page, at 7.27, where a bill of lading is issued to a charterer, and then endorsed to a third party, it attains contractual status upon endorsement on the basis that a new contract appears to spring up. And Her Ladyship quite rightly referred to that because my learned friend had submitted that actually the Bill of Lading reattained its contractual status upon endorsement. She said that is inconsistent with the argument advanced that somehow the existing contractual status was reinvigorated. So, as I've said, Her Ladyship quite correctly relied on those two passages. And indeed, if we just dwell on the passage at 723 for a moment, as I submitted to your Ladyship yesterday, the proposition advanced by the bank is that the Bill of Lading always contained or evidenced a contract of carriage. But as we see from 723, the point's made there that where the bill is in the hands of the charterer, the only relevant contract is the charter party, and that notion is entirely at odds with the notion that the Bill of Lading has any contractual force of its own in this context. There is only one contract. It is the charter party. So how the Bill of Lading can contain or evidence that is hard to understand. So that's further good reason why the bank's primary case is wrong. Just for the sake of, if you like, completeness, there's two passages also cited in the judgment from textbook Scrutton and Carver, which we also rely upon. And again, I think I can refer to them in the judgment rather than go to the text, although they're in the bundle. The first is on paragraph 41 of the judgment on page 51. And if I might just ask the court to read that, but in particular, of course, the words that are underlined by the judge herself. So, we say that point's the same way as everything else we've shown you, and likewise the passage from Carver, which is cited in paragraph 43, and there again the relevant wording has been underlined. You'll note in the fourth line the observation by the editors. Again, the difficulty is that before the transfer, no contract of carriage is contained in or evidenced by the Bill of Lading, contract of carriage being at this stage contained in the charter party. So, directly contrary to the bank's case in our submission. And just for good measure, if I may...
No, can I just unburden myself of a slight bugbear? When we have textbooks in the authorities, can we have the frontispiece, please, so that we can see not just the date but the authors? That's the fourth edition, which I think was Gunter Treitel still, wasn't it, and Freddie Reynolds. we've got in our bundles the 5th edition, which is since Professor Tritle died, and I'm quite interested to see who the editors are of that.
My Lord will ensure that that comes to your Lordship. I don't believe, unless I've missed something, that the passage is different.
I'm sure it isn't. I'm burdening myself with a general bugbear.
Indeed.
That's what ought to happen for all citations of textbooks when they're photocopied.
Well, I apologise on behalf of both sides in
Thanks.
that context, my Lord. My Lord, the one further reference, just to make good the point, and again I apologise for the absence of the relevant frontispiece, but it's Benjamin Sale of Goods, which you'll find in tab 24 of the authorities bundle. And it really makes the same point, but at paragraph 18-279, we saw above that where a bill of lading was issued to a shipper who was also the charter of the carrying ship, the bill of lading was between shipper and carrier, normally a mere receipt. It neither contained nor evidence.
Well, this just lifts what's in Carver, doesn't it?
It does.
Actually.
It does.
It doesn't
There may
demonstrate any independent thinking.
Sorry to stand up. It's obviously my fault that the frontispieces aren't in the bundles. 5th edition of Carver is Reynolds and Rose, Francis Rose.
And this chapter was edited by Francis Rose, but
Yes.
Professor Reynolds was the general editor. I see.
No.
That explains it.
Well, my Lord, there may be no original thinking in that, I accept, but it does emphasise that all the, what I might describe major textbooks speak with one voice on the particular issue. So we submit that from everything that we've seen, as the judge found, the primary case now advanced by the bank is untenable and unsupported and the authorities. That, in our submission, therefore leads to the essential question for the court is whether, and if so, on what basis, the continued possession by BP of the bill of lading after it ceased to be the charterer changes or might change the nature of the bill of lading from a mere receipt to a contract between owners. That's the question as we posited in our skeleton. And this, of course, is where the bank's, if you like, secondary argument comes in. It's said below and in its skeleton on this appeal that where the charterers cease to be charterers, that situation is no different from where the bill is endorsed to the third party. Now, that assertion by the appellants begs the question of why those two factually different, and we say radically different scenarios, should be treated the same. Now, it may be merely a forensic point now, but in its skeleton, the bank offered no principal explanation for why they should be treated the same way. And indeed, you'll see from the judgment below, they failed to do so at that stage as well. I think we saw yesterday the emergence of an argument by my learned friend, and I think the nub of it was that you should see the party's intention as being that a contract arises, and that was based, as I understood it, at least on my understanding of said, principally on the proposition that it cannot have been the intention of the parties for there to be no contract between BP and owners following the novation. So that is the case as it's developed. As I'll come to, that's a bad submission in our submission, but it did seemingly come with an acceptance that the answer lies in looking for the presumed intention of the parties. Now, we'd set out in our skeleton why we said the presumed intention was the correct approach, and we refer there certainly to the dictum of Lord Esher in the Duke and Ward in paragraph 23.2, and I referred the court yesterday to the remarks of Lord Justice Lindley in Rodiconacci, which supports the notion that the intention of the parties, the presumed intention, is the relevant yardstick. Now, in light of what I think is now common ground, that is the correct yardstick. I'm not sure whether I need to take the court back to those references. I'm very much in your hands.
Not for me.
Thank you for that indication. So that is the proposition, I think, which now guides us. And indeed, we would say that a self-evident proposition that is consistent with the approach the court adopts in circumstances such as the implication of a term, or indeed the implication of a contract. And there was a case, MF Global, where the court looked at the question of whether it could imply a contract, not just a term. And the essential approach being the same as with an implied term, you have to see it as necessary in the circumstances. So we would say that is a direct analogy to the position here. The court should look whether it's necessary to imply or propose a contract in the circumstances as they pertained. Now, as I said, in answer to this question...
Sorry, so in post-contract, are we not looking at the intention at the time that the bill is issued? Of course, there may be a subsequent contrary intention. You say in this case you find it in the novation agreement. But don't we have to look first at what the intention is when the bill is put into circulation?
My Lord, I accept that there's two stages potentially to this exercise, looking at the bill when it's issued, and then subsequently, obviously, the act which is said to give rise to it is the novation. So one has to look at both in our submission.
Yes, the reason I raise it is I think there's a danger of conflating what the general principle should be, as it were, and then secondly, whether there's a contrary intention to be found in the particular circumstances of this case. I mean, we're dealing with a charterer who ceases to be charterer under this particular novation agreement, and we may have to look at it and see what intentions or not you can tease out of it. But there's a logically anterior question as a matter of general principle. What's the intention when the bill is put into circulation? And it may be that the intention is that it should be a contract of carriage with everyone, save to the extent that that other person has other contractual relations with the owner, which are intended to take precedence. That may not be formulated very well, but if one could look at intention at the time of issue in those sort of terms, and then say, well, when a charterer ceases to be charterer, prima facie they fall within that general rule, but subject to contrary intention. So if the novation agreement in this case shows a contrary intention, that's it. But that's particular to the facts of this case. And I just raise that because I'm anxious that we should just try not to weave too much between the two strands.
My Lord, I understand that, and as submission, I accept there's a two-stage process. However, in our submission, that when one looks at the position when the bill of lading is issued, there is no basis for, in our submission, inferring or finding an intention between BP and owners that their contractual rights be set out in the bill of lading at any stage. By definition, they've got a different separate contract. And so the starting point is that if we look at the time of the bill of lading is issued, they intended and agreed that their contractual rights be set out in the charter party, and hence why it is a mere receipt. We'd submit in that context, and equally obviously, at the time the bill of lading was issued, the bank can't point to anything from which it can be said that BP and owners intended and agreed that that relationship would be governed by the bill of lading to the extent that its actual contractual relationship by the charter party came to an end. And indeed, standing there in the position of BP and owners, and setting aside the unusual facts of this case, we submit there's no reason to suggest that a reasonable person in those parties' position would have foreseen at the time the bill of lading was issued, the possibility of BP ceasing to be charterer. You have to put yourself...
Well, BP certainly did, because it was in their contract, their sale contract.
My lord, but the owners weren't party to that sale
When you
contract.
said the parties,
Yes.
certainly one of them did.
Well, my lord, of course, but one party's intention or understanding isn't I respect, relevant to this inquiry about the presumed intention of the parties to the bill of lading. You know, there's no suggestion that we were aware of, understood what BP's arrangements were with Gulf. So we'd submit at this stage, you must put that to one side and just look at parties to the putative bill of lading contract.
Well, one doesn't. I don't know. I don't know whether the owners have been involved in novations before.
Well,
you may be right. You may not. But again, I think we're in slight danger in taking the particular rather than the general.
Well, I hope I summarised those principles in the general, saying actually we look at the position of the parties to the putative bill of lading contract, BP and the owners as we understand them to be in this context. That is what we submit. One can deduce there was no reason to assume any intention on their part that the charter party relationship would be replaced by the bill of lading relation if BP ceased to be charterer.
Are there any other circumstances in which, other than a novation, in which the parties might contemplate that the charter party would cease to have effect during the voyage?
It's hard to imagine other, I suppose, than a repudiatory breach that's accepted.
You could have a case where, in the case of a time charter, certainly, where there might be withdrawal for failure to pay.
Time charter trip, yeah. Because we're really looking at voyage.
Yes.
Quasi-voyage charters,
Yes.
but time charter trip, withdrawal for non-payment of hire.
Non-payment.
Yes.
Or if you have a termination for war clause, where if war breaks out between particular states, that gives a right to terminate. So there are a number of circumstances one can postulate where the charter party relationship might be terminated. I mean, the cost case itself is one of those cases where there was termination of a time charter for non-payment of hire, and the cargo was left on board. And the issue is what happens then? And it's interesting. I mean, sorry. If it's convenient to say this,
I was simply asking for identification. I think it's legitimate for you to stand up and identify, but perhaps leave any submissions until it's your turn.
Yes.
Thanks. Thank you.
Well, look, as I say, we're in the scenario here of a voyage charter, which is the BP void form. So that's the scenario in which the parties found themselves. There are possibilities, my lord, but I would submit that doesn't affect the basic premise that we've just made, is that actually when one looks at the scenario, you can't infer an intention that should BP cease to be charterers. Or firstly, I said that other than any of those possibilities that might apply to a voyage charter, there's no reason the parties to assume BP would cease to be charterers in the way that they did in particular, or that there was therefore an intention in those circumstances for the charter party to be replaced by the bill of lading contract. So that's our position, my lord, our submission on that. But we do submit, and I fully accept your lordship's distinction between, if you like, the general and the actual. But in any event, in our submission, when one looks at what actually happened here, whether your lordship considers there was a necessary intent, or one has to look for that necessary intent in the novation, in our submission, the novation would negate any intent that might be found in the issuance of the bill of lading itself, because the terms and the circumstances in our submission are entirely inconsistent with that notion. Indeed, there's no suggestion by the bank that the owners and BP agreed in the novation that there was now a contractual relationship between them in the bill of lading. And in fact, a major, if not the major, object, aim of the novation was to terminate the existing contractual relationship between owners and BP certainly going forward. And as the judge accepted in the judgment at paragraph 46, it is, we submit, perverse to infer the creation of new contractual rights and obligations between BP and owners in a document, i.e. the bill of lading, which wasn't a contractual document, from an agreement, i.e. the novation, which brings and has the effect of terminating the existing contractual relations.
Is there any evidence that at the time of the novation, the owners knew what the position was, so far as title or risk or who was holding the bill?
We will check, but I don't believe there was.
No. I mean, one wouldn't expect them to.
No, I don't think there was any particular knowledge in this case.
No. So, if one looks at the position of the owners at the time of the novation and consider what their intentions might be, so far as they knew, it might be the case that BP were still had an interest in the cargo and were still the holders of the bill. If the cargo had become damaged during the course of the voyage post-novation, and BP wanted to sue for that damage, you say the intention of both parties was they couldn't do so as a matter of contract, and if they did so in bailment, the owners wouldn't have the benefit of all the Big Visby rules, defences and limitations which would arise under a bill of lading contract.
But that, my Lord of respect, that's the flaw in Mr. Russell's argument, because I mean he made a lot of play of it, but actually in that scenario, what would arise is a bailment on terms, and the terms of that bailment would be the charter party. So BP would, owners would be entitled, and you also may remember in practice it's a regular occurrence. Cargo come along and say, oh yeah, you damaged our cargo, we've got a claim in tort or bailment, and the response is, well, that's all very interesting, but the bailment to us, to owners, was on the terms of the charter party.
No, but the charter party doesn't. It can't be post-novation. I'm positing the damage occurring post-novation. At that stage, so far as the subsequent conduct of the owners is concerned, they're not in any contractual relationship under the charter party terms with BP. So the owners couldn't say to BP, oh well, actually, our obligations or liabilities are governed by the charter party because it's deemed to be a bailment post-novation on the terms of the charter party. The answer would simply be, it's clearly not. The intention was that the charter party would not govern the relationship for post-novation.
If I might submit, my Lord, I think that's to confuse the contractual and the pure bailment analysis. At this stage, you're positing a situation where, as I understand it, BP remains the owner, so it's saying I've got rights in this cargo which you've infringed, I'm suing you in tort or bailment. The cargo has always been bailed to us on the terms of our charter party. Whether BP is directly party to that charter party or is further away in the relationship. If a cargo interest has no direct relationship, I mean we've dealt with this very recently in a number of the highly publicised actions going on in the limitation context. A lot of cargo have come up in the Ever Given and the Maeskonam and said, actually, we've got cargo that's damaged or delayed, etc. And the response is, and it seems to be common ground, well, any bailment, any tortious relationship is governed by the head bailment, even if that cargo interest, and in this context, BP is, on this hypothesis, simply a cargo interest, that their cargo has been bailed to us on the terms of the charter party. So I would respectfully suggest that the bailment on terms analysis does does apply in that situation.
So you say that the charter party terms affect the bailment even after that those terms have ceased to have effect, because you say, presumably, that was how we received them, and therefore it's stuck with those.
In my submission, if you look at purely the bailment relationship, set aside what the contract position is, that bailment to us, owners, has always been on the terms of the charter party.
And so you can do what you like with the contract, but those are the terms of the bailment, always.
Well, exactly, and in this context, because my learned friend said, oh, well, you know, there must be an intention for there to be a contract between BP and the owners. But in our submission, and he said, oh, well, what happens if something happened? There are a number of responses. The first is, as Lord Justice Popplewell indicated, that anything that's happened already would be governed by the terms of the novation.
But something
happened after. But our first point is that in actual fact, and when we're looking at the intention of the parties, BP at that stage had no interest in the cargo, so it's very unlikely that anything would arise. If you're looking at the intention of both sides, one has to bear that in mind. But if it did, the relationship it has with owners, the cargo in which it has an interest and it's suing either in tort or in bailment, by definition that bailment is on the terms of the charter party. So let's assume
that wouldn't be the case vis-à-vis an endorsee. You'd be saying vis-à-vis an endorsee, we're bailees on the terms of the bill.
Well, there'd be a contract then, my lord, with them, which obviously...
Quite, but that shows that it isn't a question of what the contractual relations are at the time that you take possession. It is a question of what the terms are by reference to the contractual obligations that you owe. I agree. You would say to the endorsee from a shipper charterer, if you were the owner and you were sued in bailment, I am bailee on the terms of the bill of lading. And the reason you do so is that that's the relevant contract between you, the owner, and the endorsee bill of lading holder, not the charter party.
But my lord, unless I've misunderstood, in this scenario, we're putting to one side any contractual. Look at BP. They assume they have an interest in the cargo, and something happens. The point was made. Well, you owners couldn't rely, for instance, on the Hague rules if a claim was brought for loss or damage to the goods. But in my submission, if you just clear away all the previous contractual, BP in that circumstance would be the bailor of the cargo to us. That bailment would be on the terms of our charter party, and we would be entitled to rely on the terms of that charter party in response to any claim. So that's...
Well, I understand that's your submission.
Well, my lord,
but it does depend upon bailment, the terms on which bailment is being performed, being defined forever by reference to the contractual terms when receipt is first taken, whereas what one's looking at is a breach of a duty of bailment where the terms of bailment may change and do change in the case of an endorsee from the charterer.
The scenario here is we're asking the question: is it necessary, if you like, to imply a contract between BP and owners post novation? Is it necessary to imply a contract on the bill of lading terms between BP and owners? What was said is, yes, the parties must have intended that to be the case, because otherwise there'd be no contractual relationship and owners wouldn't have any right to rely on the Hague dispute. In that scenario, in my respectful submission, the bailment on terms can only be, we have a bailment, we still have a charter party in place. Gulf has assumed the role of charterers. They've effectively bailed the cargo to us. That cargo has been bailed to us by them, and obviously it's come from, in this notional context, BP. It's been bailed to us on the terms of the charter party. And we are entitled in that situation to rely on the terms of the charter party as governing the bailment. I'm sorry, if I'd realised this was actually, I think there's really quite strong authority on it, but obviously I may have to consider a position come back to your lordship on it, but certainly that's the position I've seen adopted in many, many cases, and may be wrong, but that's how I understand the position to be. But it's the answer we would submit to the point that Mr. Russell has made, that actually there wouldn't be any relationship, and that's a problem. We submit the bailment would be on the terms of the charter party. My Lord, if I may just then say also, when one's looking at this position under the charter party, we would submit that taking up the position of owners in particular, they can't objectively be taken to assumed obligations under the Bill of Lading to BP when those are inconsistent with the obligations they had just assumed under the charter party by virtue of the novation agreement. And this comes back to the fact, Lord Justice Popplewell observed, that the novation agreement alters the permitted discharge location under the charter party. So you have a different provision in the charter party for discharge from that in the Bill of Lading. So the bill provides for discharge at Fujairah only, whereas the charter party novation, as saw the Lordship, and the reference, if it's of assistance, is tab 24, page 84. There was an amendment of the charter party. Maybe it's worth just taking the court to that. Supplementary bundle, tab 24, page 84. So it's volume 1 if we have separate. And at paragraph 7.2, just by the bottom hole punch, you'll see the charter party discharge range is hereby amended to include SOHAR, all STS spots including anchorage, etc., for the new charter account. So there's an amendment of the permitted contractual voyage. So the notion that BP and ship owners kind of intended for a contract to spring up for the voyage in the Bill of Lading, when the very act which is said to give rise to that agreement amends or alters that voyage, is in our submission very hard to understand.
But BP is not concerned with that amendment.
Well,
I know it's party to it, but it's not for the future.
But objectively, you're looking at the parties' intentions to be drawn from the novation. The analysis that they intended there then to be a contract with BP and owners on the Bill of Lading means that the respondent simultaneously assumed inconsistent contractual obligations by the terms of that novation to discharge at SOHAR if directed so by Gulf, but also under the Bill of Lading contract to deliver only at Fujairah.
Well, they'd already accepted inconsistent obligations because the original charter permitted discharge in Singapore Vietnam range as an option, but the bill that was issued was for discharge at Fujairah. Often happens. You put into circulation two mutually inconsistent documents as to discharge, and the owners are at risk, certainly at risk vis-à-vis an endorsee, from that inconsistency.
Well, my lord, that's a different scenario, because here again, you know, that contract that may be established with an endorsee by transfer is one thing, a matter of statute amongst other things. Here we're looking whether one can imply a contract or the intention to contract, and the very notion we submit that the owners, in agreeing to an amendment to the charter party and bringing to an end their existing relationship with BP, thereby agreed to contract with BP on different and inconsistent terms is a hard one to fathom. There's no objective reason why the parties in their position would be considered to have intended that to be the case.
You, just to clarify, I understand you to accept that if BP had previously endorsed the Bill of Lading, prior to the novation, it would have sprung up as a contract. So there would have been, and the owner doesn't know when or if the bill of lading has been endorsed. So in that scenario, there would also be an inconsistency.
Potentially, my lady, it would. Again, I'm looking, and basically the relevant inquiry here is looking at those parties' intentions objectively from this novation. And we do submit one looks at it. First of all, the intention was to bring an end to the contractual relationship between the parties, number one. Number two, we do submit that when one looks at what those the novation did, it changed, if you like, the goalpost. And when one's looking at the question between those two parties, BP and owners, can you infer that they necessarily intended there to be a new contract on different terms? We'd say that's not an inference you can draw, whatever else may be the case. And I repeating myself, but the objection to it is that there would otherwise be no relationship between BP and owners. Now, I've made my submissions on that, my lord. We do submit there would be a bailment on terms in that context, which would be consistent with the existing, the contractual arrangements as they were up until the novation. And what we submit is most unlikely in terms of presumed intention, inherently unlikely, is that the parties were intending for there to arise out of the document that brings an end to their contractual relationships a contract on entirely different terms. So in our submission, that is why...
Before I forget it, just arising out of my lady's question, I think when Mr. Russell was making his submissions, I suggested to him that it was accepted on your side that if the endorsement had been made post-novation, but prior to discharge by BP to the bank, then, subject to your arguments on causation and so on, there would be liability.
There would be a contract at that.
There would be a contract.
Yes, yes, and then your lordship identified, my learned friend, I think, didn't understand how we put it, but your lordship is correct, that's how we have put it.
That is accepted on your side.
But we say if that happens
post-discharge doesn't count.
Position is different. So that's indeed right, my lord. Yes.
Thank you. I just wanted to make sure I got that right.
So it's the difference between endorsement and the circumstances here where there's an ovation.
Sorry, my lady.
So really, it's the difference between an endorsement where you do accept that the bill of lading springs up, and it's the circumstances here where you say the contractual relationship was coming to an end. So how can you say that the bill of lading springs up? That's it.
Well, my lady, in one sense that frames the question, but as I said, in our submission, the analogy, well, it's the same as the situation. It begs the question, why?
Yeah, you say it's different. That's what I'm meaning. Endorsement is different from a situation in which the contractual relationship has come to an end.
Indeed.
Yeah.
So I was going to deal with the alleged anomalies. I think I've pretty largely covered that in the submission. The key point my learned friend took, as I understand it, the keystone was his proposition that it was improbable that the parties would have intended there to be no contract. I've covered that in courts either with me or not, and if we could usefully provide more context to the bailment on terms point, then I would obviously willingly do so, but I do submit that is part of the answer to it.
I mean, the bailment on terms really simply mirrors the contractual relationship. I know juridically it's a different creature, but when one talks about the owner being a bailee on terms, the effect of it is essentially that the rights and obligations in relation to the cargo are the same as if there were a contract between them on those terms.
My lord, of course, and it's
so the consequence of the novation agreement, if you're right, so far as BP were concerned, is that in substance there would continue rights and obligations on the charter party terms thereafter through the mechanism of it being a bailment on those terms.
Of course, only insofar as, I mean, you wouldn't have some of the obligations under the charter party as a charterer per se.
No.
Of course, the number of obligations that are germane to the relationship of the cargo owner and the ship owner are different.
Yes.
And that's the position in our submission. Of course, it's one of the English law's mechanisms for getting around the privative contract issue, where and I do submit it's directly the situation here is where you get a cargo interest who has no direct relationship with ship owner, comes along and says, you've damaged our goods, we've got a claim in tort or bailment, basically a negligence allegation. The response is, well, those goods were bailed to us on the terms of the charter party, the Macatai and those sorts of cases. And I do submit that the position of BP that we're looking at here is precisely that. The assumption is there's no direct contractual relationship, but it has damage or something to its cargo. And the response from our side would be, in that circumstance, there's a bailment on terms. And that would bring in those terms that are germane.
Well, and I understand.
Yeah.
It's just a question of which terms.
My lord, I see that. But that's our answer to the suggestion that there would be no relevant terms. We said there would be. And my lord, the other point that my learned friend raised was the one that you've just teased out about the position with regard to an endorsement post novation, post discharge. So I've clarified that, and I'm not going to repeat our position in that regard. There are a number of other, I think, less significant points raised by my learned friend about the alleged anomalies that arise. If I may, I will leave those as they're set out or responded to in our skeleton argument. I don't think they are in any way significant, but we've addressed them in our skeleton argument. If I may ask you to read those in due course and move then on. The point I was then finally going to touch on is to come back to the point your lordship raised with me about reliance on COGSA, on the assumption that we're right on everything else, and the post-discharge transfer of the bill to the bank. I do say, and we do say, as I submitted to your lordship yesterday, summarised briefly, this is not an argument pursued before the judge. It's not part of the grounds of appeal, and in that context, it's not a complaint about the finding in paragraph 47, nor does it support the findings for which for which the bank contend in its grounds of appeal, paragraph 3.1.
But is there any reason of substance why it shouldn't be allowed to be raised? It doesn't involve any further factual findings or anything of that nature, does it?
My lord, I don't think I can say it would require factual findings. I do submit it's a difficult...
But it's just a question of law, and it was raised in the skeleton, so you've had an opportunity to address it, and indeed have addressed it in your skeleton.
Well, we've addressed it briefly, my lord, and I would just reiterate what we said. We can start maybe with your discussion with Mr. Russell yesterday, which is page 97 of the transcript, and you posited a question, Mr. Russell. The transcript. It starts on page 97, and my learned friend at line 16 was saying on very high authority, it's a proposition that any delivery without production is a breach. It's very well established, and I say the judge erred in her analysis and failing to take that into account. Your lordship intervened, saying, how does that work where the shipper charter remains throughout the holder of the bill of lading, asks for discharge, or someone asks for discharge? There's never any contract, so is there never the contractual obligation only to discharge against presentation of the bill of lading? My learned friend accepts, I think he must. In that circumstance, the only effective contract will be the charter party, and therefore what the owner is obliged to do will be determined by the terms of the charter party. So that in our submission is the starting point to this particular knotty problem, is that it's accepted, it must be right, that in the circumstances where no endorsement takes place until after discharge, the owner's obligations are only contained in the charter party, and that is to discharge in accordance with its terms. and that's the origin of the problem, we do submit that the bank has produced no authority to show that in those circumstances the effect of the Act is to, if you like, impose a contract that never existed, an obligation that never existed on owners, not to do what they were obliged and entitled to do. My own friend is, I think, going to refer to the Aaron Schulter in the Court of Appeal, but if he does, you will see that that's a case where, it's not a case where the bill of lading contract only arose after discharge. There was already...
But that generally is the effect, isn't it, of the retrospective effect of Section 2, in cases where the bills are spent, but nevertheless Section 2 applies, that the voyage may be over. Throughout the voyage, the owners may not have been obliged to do something which is in the bill of lading contract, but once it's endorsed post-delivery, then they can be liable for breach, even though it wasn't a contract imposing those contractual obligations at the time of breach.
Well, my lord, we say that that's an extraordinary result in this context, particularly the misdelivery aspect.
Well, leave aside misdelivery, because we've got to decide whether that's different. But generally, take classic cargo claim, it doesn't matter that at the time that the damage to the cargo occurs, the bill is in the hands of the shipper and is a mere receipt. If it's subsequently endorsed, then the effect of Section 2 is that the owner becomes liable under a contract which didn't then exist. So for breach of obligations which it wasn't under at the time that the breach occurred, and that's the effect of Section 2. Now that's the general position. Then we have to say, well, if the breach we're talking about is misdelivery, is that different? Because even if one's not talking about misdelivery, the owner would still be able to advance the argument, which wouldn't be sound. Well, how can I be liable for a breach in doing something that I wasn't under an obligation to do at the time?
Well, my lord, I think that there would... I may be repeating myself, my lord, but we submit that situation, that something like dark cargo damage is inherently different, because there's always an obligation to take reasonable care of the cargo and so forth. Those are inherent obligations, whereas misdelivery obligation arises purely by the nature of the bill of lading contract giving rise to that obligation.
Well, I take cargo claim as a simple example, but one could, I'm sure, find an example of an obligation which was only in the bill of lading contract and didn't arise under the charter party arrangements. It's not unheard of. So the same would apply there.
Well, Muller,
in relation to carriage of the cargo.
Well, Muller, we do submit, and I think I've made my submissions, that may be different than in the context of misdelivery itself, the very nature of the
I understand that's your submission, and I'm just trying to tease out why delivery otherwise than against production of a bill is different from any other obligation that arises under a bill of lading contract.
Well, my lord, it's the fundamental one that is imposed, as I said, only in our submission by the bill of lading contract when it arises, and it just seems a very odd notion that can arise after the event when owners have quite legally and properly performed their only current obligations at the time of discharge. So we would submit that is a fundamentally different obligation in that context to other obligations not to damage the cargo, which would be subject to bailment and tortures all along.
Maybe I'll need to think more carefully about particular, but maybe deviation, liberty to deviate, something like that. Maybe a liberty to deviate under the charter party and not under the bill.
Well, of course, the law of deviation has rather changed over the years, my lord, so it may not be a... But, and this is coming back to my submission, why we submit, and I understand the court's point, but it's a matter that ought to have been raised properly, so then given more serious consideration because of these serious implications in the argument.
May I ask, Mr. Thomas, in those circumstances where one delivers in terms within the terms of the charter party, but thereafter there's an endorsement of the bill, etc., and then there's an issue about misdelivery, perhaps. Is it normal when one delivers in terms of the charter party to take an LOI?
I'm not sure I could say it's going to depend on the circumstances of the case, the cargo involved, and certainly in many cases there will be no LOI. I mean, many deliveries under charter parties are made without LOIs. Very many different scenarios which might be covered.
But where there's no presentation of the bill, I mean, it may happen sometimes, but my impression is that it's widespread and of long standing, not just in this trade, but in many trades, that if the ship owner is being asked to deliver to the receiver without presentation of the bill, they will often, if not always, require a letter of an indemnity from either the charterer or the receiver, even if the charter party has said nothing about it.
Well, there will sometimes, my lord, I accept that, but to Lordship's point, I'm not sure we can say there's a general or normal.
It may not be universal, but it's certainly common. Is that fair?
Yes.
Thank you.
Unless I can assist you any further on that issue, I was then going to move to issue 2, ground 2, which is causation. Now, our position in summary is as follows. We submit the judge made what are unchallenged findings of fact in relation to causation, which were fatal to the bank's claim below and are fatal to this appeal. There was, contrary to the bank's protestations, no error of law in respect of the judge's approach to causation. And in fact, as we'll see, the judge applied the very approach which the bank invited her to adopt. Applying that approach, which was the correct one, she found the claim failed on the facts. We would add that even if, which we most certainly don't accept, due to the way in which the bank advanced its case, the approach was flawed or the precise counterfactual needs revision, it's too late for the bank now to complain because she did what they asked her to do, number one. And in any event, it's abundantly clear from the judgment the answer would have been the same in any event. We submit, as you will understand, that ground 2 is a thinly veiled attempt to subvert those factual findings the court made by alleging a non-existent error of law. Now, consistent with our position, we just ask you very briefly to turn to the grounds of appeal, core page, tab 1, page 13. We can see in ground 2 that the conclusion the judge reached is plainly challenged, but the respects in which he's alleged to have erred in law are obscure. And indeed, one might ask oneself, for instance, how the bank would have suffered, how the finding that the bank would have suffered the same loss in any event can be anything other than a factual finding. Now, the alleged error of law is, we submit, almost as hard to find in my own friend's skeleton argument, albeit if we turn up that argument at tab 2, page 27, look at paragraph 55. What we see first of all is that the bank's unable to point to any paragraph of the judgment actually containing the error.
I'm so sorry, which paragraph of
Sorry,
this?
paragraph 55, my lord.
Thank you.
Can't point to any paragraph of the judgment actually containing the error, but the complaint appears to be she must have failed, in considering the evidence, to carry out the very basic exercise of comparing the two situations of breach versus no breach. That's the essence of the case. Now, pausing there, if one looks at this and the consequential submission at paragraph 61, where it says she failed both to articulating clearly two situations, breach versus no breach, in order to assess whether or not the outcome would have been the same in any event, that sits at odds with the submission made to the court yesterday, that there is in fact no relevant counterfactual to compare. Indeed, the skeleton and the submissions made yesterday we submit are entirely inconsistent with each other. The position adopted by the bank, as we can see in the paragraphs I've just alluded to, but also, for instance, in paragraph 15, is that a counterfactual is absolutely necessary. In paragraph 15, the bank articulated the problem in the last two lines, identifying what constituted a breach was the necessary precursor to identify what the relevant no-breach counterfactual would have involved and comparing the two. And the court doesn't need to turn it up, but exactly the same point is made at paragraph 66 of their skeleton. So there's the gravamen of the complaint that was made in the skeleton and pursued throughout was that by not identifying the breach, she failed to identify how the counterfactual would differ. And indeed, just to make good the point, at paragraph 58 of their skeleton on page 29, you'll see the submission in the last sentence that thus the sub-issue, this is 8.1, which is the relevant issue, requires a counterfactual or hypothetical analysis. So if the essence of Mr. Russell's case now is, and I think it was described as his fourth point yesterday, is that in fact there is no relevant counterfactual, which is how he put it. That is a very new, entirely different case to the one pursued in the skeleton. Indeed, that insistence in the skeleton, we've seen that they're counterfactual, you must compare, as it seems to us to have been.
I'm not sure that's quite fair. He says the counterfactual is they didn't discharge the goods.
Well, my lord, in relation to that, they say that, but the proposition was advanced that there can be no relevant counterfactual unless it's realistic.
Well, that's an alternative. He proceeds in stages, ultimately, under perhaps a little pressure from me. Basic point is you don't go any further than saying if they'd performed the contract, they wouldn't have released the cargo because there were no bills. You don't then investigate what would happen. That is a counterfactual. If he's wrong about that, he says that if you look at what would then have happened, you can't put in place the hypothetical, which I put to him, of discussion between the parties ending up with the bank, because that's not realistic. And then as a fallback, I think this was his proposition 6, even if he's wrong about that, the judge hasn't made any findings about what the bank would have done, or what all the parties would have done by way of what he described as heavy lifting to make the factual findings. So I think it's not quite fair to say that his argument depends upon there being no counterfactual or a counterfactual which couldn't have taken place.
Well, I'd invite you to read, and I accept what your lordship said, but the transcript at 102 to 105, my learned friend describes there being no relevant counterfactual.
But those are the arguments you've got to grapple.
Indeed. And in our submission, when one looks at it, but just make this point, is that if that is his counterfactual, either the vessel, sorry, the cargo would have stayed on the vessel. If one's limited to realistic counterfactuals, that is not on his own case a realistic counterfactual. Now, in the sense that there has to be a counterfactual, his own argument's self-defeating, because that proposition, he says, is itself either improbable or impossible. So it's an argument which leaves the court nowhere in our submission, and it's plainly wrong. Indeed, So it's a new and critical, possibly part of his case, but it would more generally introduce a new and we submit unwelcome inquiry into the approach to causation, not just in this case, but more generally. It would be a question that the court in any case would have to now grapple with, so he says, and we submit not just on causation, but also in the assessment of damages, which we submit must proceed on the same basis. You have to look at the counterfactual and ask whether it's a realistic one. And that's not, I'm bound to say, a proposition, profoundly important though it would be for causation and the assessment of damages, that I am aware supported in any form in the authorities. Now, of course, we didn't hear this argument until yesterday, so we haven't been able to do that research, and we will if the court would find that of assistance. But we do submit that it's an entirely novel proposition of law, and one for which my learned friend cited no authority. In our submission, the approach is the one that we've advocated, which the court has identified, or Justice Popplewell identified in his discussions yesterday, and which the judge adopted. And this diversion really is one that seeks to avoid scrutiny of the case advanced before the court, which we'll come to shortly, because what the bank now says is a very different proposition to that which it invited the court to adopt and the approach which it advocated. Now, in this context, given the complaints that are made about, for instance, the lack of clarity or the absence of findings, I think it is inevitable to show you how the issue arose and the context in which the court addressed it. Because in our submission, when one sees that, we will see that, as I've already submitted, the court did no more than answer the question that was put to it. And it also puts in context the findings made by the court in the judgment. Now, we had a brief skirmish, or a brief diversion into the pleadings yesterday, but I think it's important to look at all the parts of the pleadings that are relevant, because it sets the scene. If I could ask you to start in tab 10 in our defence, amended defence. First of all, paragraph, very briefly, 77.1, which I think we did go to yesterday. Just trying to give the court an overview of all the relevant parts. It's page 130, I'm sorry, of tab 10.
And we're looking at 77.
77.1.
Point 1 at the bottom of the page.
There was a denial of loss and damage, and you say 77.2, any loss and damage was caused by the claimant authorising and receiving or requesting missing Gulf to arrange discharge. Then I think we also touched upon this at paragraph 81.
So those are both addressed to the authority and approval which the bank gave to Gulf, aren't they?
My lord, that's the right context, that part of the plea, yes. And at 81, it says, a matter of law, the claimant is entitled to damages, only to damages to put in the position it would have been if the bill of lading had been performed in accordance with its terms. And
so that's my fault, I'm just making a note. Where do we go after 77?
Page 135, paragraph 81.
Thank you.
And right at the bottom of that page, I've just, my lord, read the first sentence. At the bottom of the page, the claimant is thereby put to proof that it would not have suffered the alleged loss and damage it claims to suffer in any event, namely if there had been no breaches as alleged. My learned friend, I think, complained yesterday that we hadn't set out a positive case. Our simple point is that it has always been, it was common ground, it's the claimant to prove its loss, which includes the question of causation. We're entitled to put them to proof as we did, and entitled to test their explanation in due course, which we did. Now, the response from the bank is in its reply. First of all, if I could direct you to paragraph 60, which is on page 147, which is the response to paragraph 77 that you've seen. And it's effectively a response that denies that there was authorisation, etc., on the part of the bank to approve a request to permit Gulf to discharge finance cards of the Cutch Bay and the Prestige without a bill of lading. And I think the paragraph you didn't get taken to yesterday is at paragraph 64. So in response to paragraph 81, it said, had the owners performed the bill of lading contract in accordance with its terms, it would have discharged or delivered the cargo, would not have discharged or delivered the cargo without presentation of the original bill of lading, and or it would not have discharged or delivered the cargo without authorisation of the bank, and or to any party other than the bank or the bank's order. So pausing there, submit what you have is the bank's pleaded case as to what would constitute lawful performance of the bill of lading contract. And as you'll see from the pleadings, there was really no difference between us in the approach. The real question is a factual one, and it is that factual question which the court sought to determine after the trial. Now, it's perhaps a sideshow, but since we're here, I do say that if we turn back to paragraph 36 of the reply at page 143, the bank's position as to what constituted lawful performance of the bill of lading contract is consistent with the response in paragraph 36 that it would have no cause for complaint if the cargo had been delivered to the 6 sub-buyers which it had approved and which are referred to in that paragraph. And so it may be a sideshow, but my learned friend sought to suggest that you don't get that from paragraph 36, but when you look at the different aspects of the pleading, our submission that is actually consistent with paragraph 64. In any event, the court will note that the judgment accurately records the pleaded case of both parties at paragraphs 52 and 54. You will find that on page 4, 5, pages 53 and 54. The judge was at pains to set out those paragraphs, or at least part of those paragraphs that I've just cited, and submit therefore she had well in mind how the parties, each party, had advanced its case. Now, in the context of the argument as it was advanced at trial,
the judge has put the emphasis in quoting paragraph 64 on the first part, but paragraph 64 does also, as an alternative, says it would not have discharged or delivered the cargo without the authorisation of the bank.
Indeed. But my lord, I understand she's emphasised part of it, but she understood the arguments advanced by both parties and she cited them in full.
I follow that.
But
does that part of paragraph 64 not raise exactly the issues which Mr. Russell is relying on?
Sorry, my lord, I didn't.
Does that sentence phrase in paragraph 64, it would not have discharged or delivered the cargo without the authorisation of the bank, does that not raise the issues which Mr. Russell say the judge should have addressed and failed to address?
Well, in my respectful submission, she did address those very issues.
Right.
And the exercise I'm hoping to perform is to show you that she had well in mind all of the arguments that were raised.
Well, I quite understand that, but you're also making the point that she addressed all the issues, and that the way that it was now put by Mr. Russell wasn't something which was pleaded or advanced to her. And speaking for myself at the moment, it does seem to be pleaded.
Well, it's one of the strands of the argument, but
Yes.
the argument was a broader one, and as we'll see from the way it was put to her orally, if it was accepted, we will submit that if the bank would have authorised discharge in the way that she's found, then that was defence. So I'll come to show you, Your Lordship, that now, if I may. The precursor to this is that my learned friend submitted yesterday, and indeed in the supplementary skeleton at paragraph 21, that somehow the judge has misunderstood or misrepresented the case on counterfactual, and that somehow it only relates to quantum. I think they say, they do say in paragraph 21 of their supplementary, owners attempt to bolster the judgment by trying to turn banks' closing submissions in relation to a quantum counterfactual into findings of fact. Now that was repeated yesterday orally, but it's, as we'll see, simply not correct. In that regard, I would ask you to take out a supplementary bundle, and I think it must be volume 2, tab 93. And if I could ask you to pick it up at page 525. As the court will see on page 47, at line 20, these are Mr. Russell's submissions, and you'll see at line 20 saying in relation to causation argument. So it's important to understand this is all about causation. And he says, as I understand it, the way in which it's put is that even if there'd been no breach, the same loss of the bank's security interest would have occurred in any event, because the bank would have agreed to the cargo being discharged into the Cutch Bay and Prestigious in the same way as in fact happened without production of the bill of lading.
I'm sorry, I can't find that. So we're at page 525 of the bundle, and we're looking at page 46 on that page at line 20.
So 47, my lady.
Thank you.
I apologise.
Sorry. Got it now. Mm-hmm.
It says in relation to causation.
Yeah.
And then on 48, now pausing for a moment, the first and foremost fundamental observation, if there was no breach, the cargo stays on the vessel either until the bill of lading is produced or the owners are in some way satisfied that it's safe to discharge or deliver the cargo. He then discusses Mr. van der Geer's evidence, and at line 13 he says, but the starting point, and I emphasise he doesn't say the end point, the starting point is that if owners do not breach their contract contained in the bill of lading, the cargo stays on the vessel until the bill of lading is produced. In my submission, it's for owners to persuade you in those circumstances that notwithstanding the fundamental proposition, nonetheless the cargo would have ended up being discharged into the Cutch Bay and the Prestigious, and discharged into the Cutch Bay and the Prestigious, notwithstanding the bank's very clear understanding that the only circumstances in which it had authorised discharge was to discharge the 6 identified off-takers in for Gyra, and that discharge into the Cutch Bay and the Prestigious would have taken place notwithstanding that it would have been inevitable that the bank would have discovered Gulf had been acting in a way in which it was entirely inconsistent with the way in which Gulf had been telling the bank it had been acting. Our submission is that it's just fanciful to suppose that in the case where owners did not breach the bill of lading contract and the cargo stayed on the vessel and investigations took place, that the bank would have agreed to discharge into the Cutch Bay and Prestigious. And pausing there, we'll see that that is the counterfactual scenario which the bank advanced throughout. They said that if somebody had come and said, we want the original bill of ladings, this would have tipped us off, we'd have taken steps to investigate and we'd have found out about the fraud. He goes on, And insofar as I can see, the submission that my learned friend makes in his closings are essentially a repetition of the points that he put at length to Miss Bodney in his cross-examination of her. And we say that Miss Bodney was patently an honest witness. There may be scope for argument as to whether her interpretation of documents or events at the time is objectively correct or not. But we say she's clearly given honest evidence as to what her understanding was at the time, and she was adamant that she would not have agreed to discharge into the Cutch Bay and Prestigious. I think we counted 7 times it was put to her that she would have agreed. Each occasion it was equally adamant that she would not have agreed, and of course the judge found that was not evidence she could accept. Now, I don't intend to go all her evidence now. We've dealt with it at some length in our written note, and I may pick it up on particular points in reply, but your lordship would have formed your own view of Miss Bodney and her evidence. And as I say, we invite you to accept her evidence as truthful and representing the true position, that she would not have agreed to discharge into Cutch Bay and Prestigious, which is the necessary element for owners to establish any case of defence based on causation. So pausing there, this is all about causation, contrary to my learned friend's skeleton submissions yesterday. This is not some mischaracterisation of case on quantum, and indeed you'll see, just to complete the picture on page 51 at line 11, it says, so those are the liability issues. And that position is consistent with the approach that was taken in opening, and if I could ask you in this context to go to tab 88, which is the oral opening, page 462. On page 51, which is top right, it's just a short passage, starts at line 5. Then fourthly, causation. Even if there had been no breach, would the same loss, which is the loss of as securities, have occurred in any event? Obviously, that involves the investigation of the counterfactual situation as to what would have happened if owners had not breached the contract. That was stated to be obvious, that comparison. And the only counterfactual advanced by the bank is the one that I've described. Would Miss Bodney have agreed, would the bank have agreed to discharge in any event? And that is clear from, amongst other things, the bank's own skeleton on the appeal. If I could ask you to turn up tab 2, page 36. Now, this is a submission made in the context of issue 8.2, not 8.1, but as you'll see at paragraph 80, subparagraph 3.
Sorry, 80, subparagraph 3.
Page 36, full bundle.
So I've got mine unnumbered loose, so just if you could give me the paragraph numbers.
80,
again.
subparagraph 3.
Thank you.
Page 22, internal.
Thank you.
Was the bank's case that it was reasonable to suppose that in the hypothetical counterfactual scenario, where owners did not breach the bill contract, did comply with the contractual obligations, refused to discharge to Gulf, that prudent ship owners would have sought the instructions of BP as a lawful holder, which would in turn have led BP to tell the ship owners to contact the bank as the intended endorsee. So that's the counterfactual that they advanced, indeed the only counterfactual. And so what the bank is identifying there in the passages I've cited is the essential factual question for the judge, and it was accepting that if the judge held on the basis of the evidence that had owners initially refused to discharge against the bill, but that the cargo would nevertheless have been discharged with the bank's agreement, that owners would have a causation defence. They, of course, said factually that is not what the bank would have done, but that is the essential question raised, and we say an acceptance by them that if that factual finding was made, there would be a defence. Now just pausing there, firstly, we submit that the suggestion in the supplementary skeleton, which is that we're misrepresenting the closing on quantum, is obviously wrong for the reasons I've shown you. That simply is not the case. Secondly, the bank's position and its submissions were accurately recorded in paragraph 60 of the judgment. And if I direct you in particular to the last sentence, it's the claimant's submission, relying on evidence of Mr. Borchardt, that in that situation the bank would have engaged with owners and asked them not to discharge the cargo without its consent. And that's a factual issue which in due course was decided against them. And likewise you'll see in paragraph 63.1, reflecting the passage from Mr. Russell's closing, claimant submitted the evidence of Mr. Bosnich should be accepted as truthful and representing the true position, that she would not have agreed to discharging the Cook Bay in the prestigious, which is the necessary element for owners to establish any case.
I'm so sorry, it's my fault. Where are you now?
63.1, model, just at the bottom of page 56 of the court. Really just to show the court that those arguments were accurately reflected in the judgment. And thirdly, the counterfactual on causation is unsurprisingly, and we say necessarily, consistent with the quantum case advanced by the bank at trial in relation to what would have happened in no breach scenario. And we do submit, firstly, when we heard from Mr. Russell yesterday that you could have a different different counterfactual for causation and quantum, we find that a baffling submission. But both must, we submit, self-evidently be the same. And so even if he is correct that the judge had referred to the quantum arguments, or they were put, it doesn't matter because that is their counterfactual. And in this regard, we can see a little bit more detail how it was put in the written submissions. If I could ask the court, first of all, to take out, again, the second supplementary bundle, and it's tab 86. Page 395 of the second supplementary bundle. Paragraphs 128 to 131. Maybe I could just ask the court to read those themselves.
128 to
131.
Thank you.
I'm so sorry, I'm in the wrong bundle. But
I'm
getting behind because I'm trying to make a note.
Tab 86, page 395. And I directed the court to paragraphs 128 to 131. So again, that reflects the counterfactual they're advancing, and we do submit that it was, but must necessarily be the same as the causation counterfactual. So we understand what the issue was that was identified for the court. And for good measure, that was repeated or a version of it was repeated in the written closing at tab 91 at page 488. What the bank does here, it says, for ease of reference, the evidence is the steps that would have been taken if owners had not breached the bill of lading contract and refused to discharge the cargo without production of the bill of lading set out below.
Sorry, where are you?
My lady, I'm sorry, it's paragraph 44 of... And they describe, firstly in paragraph 45, owners would have sought instructions from BP and the bank. And they say then at subparagraph 3, had BP been contacted by owners asking for details of the whole of the bill of lading, it's reasonable to assume that BP would have advised owners that the bill had been sent for endorsement and transferred to the bank. And then they pick it up at 46. Owners have not adduced any evidence as to what would have what they would have done in the event that they had not chosen to breach the bill of lading contract. They have not challenged the likely sequence of events. It is presumed that they therefore accept that the bank would have been contacted by owners, informed of Gulf's attempts to obtain discharge at Sohar, and asked what it wanted to do. This was the premise of the cross-examination of two of the witnesses. Its case is then that if it had been contacted, it would have effectively carried out investigations, which is what is said at paragraph 47, which mirrors the closing submissions that my learned friend made at page 526. Cargo stayed on the vessels and investigations then took place. So there's a consistent case as to the counterfactual that the court had to consider at the hearing of this matter. And as I've said, it's the same counterfactual that arises in connection with causation and quantum, we say necessarily so. And of course it was that question, the fundamental question posed by the bank, what would they have done if owners had said, well, we need a bit of lading, which the judge answered. And again, she accurately summarised these arguments in her judgment, and she answered that question, but she answered it against the bank.
Mr. Russell, if we go slightly earlier in that closing, paragraph 11.
Sorry, paragraph 11.
Yeah.
Sorry,
I'm sorry, I closed where I am.
Page,
yeah.
I think it's hard copy 478.
Sorry, mate, to just catch up, we're in
Yes.
paragraph.
Yeah, 11.
Yes.
I'm just conscious that the way that I read the closing note is it basically says the arguments fail in principle for the reasons given in paragraph 11, and then goes on from paragraph 12 just to address the facts, but effectively on an in any event basis. So, but the fundamental that makes the point at 11.2, for example, that the cargo would have remained on board the vessel and the bank would have suffered no loss.
That's a repetition of their case as to what would have happened in the counterfactual.
But then what I'm trying to say is that, does that suggest they're not resting their whole case on the factual position, are they?
That's not how it was run, as you've seen from the transcript of how it was submitted in closing. So
you say they moved, there was a move from what this appears to say to closing to rely only on the factual position.
Well, they posited a counterfactual, and as you've seen, they said in that part of the submission that the essential premise is that they authorised discharge if the owners had come and said we need the bills of lading. We'd have a defence of causation. If the answer is yes, you would have allowed them to do that in any event. So I do say that is the essence of the case that was run. And think that is exactly what we've seen from the transcripts and the references in those transcripts. And as I said, that is the essential factual question that the court was posed, and you will have read the judgment. The judge set out, in light of that, to consider the evidence, and she did hear from Miss Bodney at length, and you'd have seen her consideration of that evidence, and she concluded as a result that in the hypothetical no breach situation, the same result would have occurred. And that was her conclusion on the facts. Obviously, it's not what the bank had contended for, because they said it would have triggered an investigation and we'd have found about the fraud and so forth. So what she correctly found in our submission was that the proximate or effective cause of the loss was not the missed delivery, because the claimant would have suffered the loss in any event. I mean, in so doing, she effectively accepted, my own friend referred yesterday to a submission we made, that there was no alternative reality in which the cargo wouldn't have been delivered, and that was the scenario which she accepted to be right. As we submitted, it was put to the witnesses, if this had arisen, you would have authorised discharge in any event, and that's what she found.
So if the correct counterfactual is what I was putting to Mr. Russell, have I understood you to be saying that it was conceded, essentially, that all the steps up to whether the bank would give its consent were common ground and conceded? See paragraph 83 of the skeleton, which reflects paragraph 45 of the note for closing, albeit that those were in the context of quantum, because A, the argument's no different for quantum than it is for causation, and B, when Mr. Russell came to address the factual position, he did so in the context of causation. So that the question which the judge was addressing was, if the owners had said, we're not going to discharge without the bills, then it's common ground, essentially, that what would have happened is that there would have been a request of BP would have directed the inquiry to the bank, and it would have been determined by what the bank would have done, and that was what the evidence of the witness went to, and that's what she was deciding, i.e. what the bank would have done had that all happened.
That's the central question.
Is that a fair encapsulation of
it is.
this submission?
That is a fair encapsulation of the submission. That essential factual question was the one that was posed.
Yeah.
I accept that we may have suggested that Gulf may have come to you and say and broke bad news rather than BP, but it doesn't matter analytically to the key question, which is what would the bank have done in those circumstances. And that's,
if asked by the owners. I mean, the important fault line, as it seems to me, between you and Mr. Russell on this is that his case is that all the judge was addressing is what would have been agreed as between Gulf and the bank, whereas you're submitting the right question, and it was the question the judge answered, is what would the bank have said to the owners, and that was what she was addressing, because the rest was all common ground.
Indeed, but the suggestion that it was, I don't understand the notion that this was somehow a conversation between Gulf and BP, Gulf and the bank only, because on this scenario, owners have said, we're not delivering without the bills of lading, so consent would...
Something would have had to be said to the owners to persuade them otherwise.
Exactly, and whether that's absolutely directly from the bank or the bank via Gulf doesn't analytically matter. That would have been communicated to them. So that distinction doesn't, in our submission, actually make sense in the context of the position that the question the court was adopting.
I follow.
And we do submit that is the correct approach and the correct question, not least because, and we may touch on it shortly, but I think it was agreed by Mr. Russell that express consent is a defence, and that is part and parcel of the case, as you've seen from the pleadings. So, but that's the factual question, the fundamental factual question that was posed, and maybe repeating myself, but the court considered this 4 days of evidence and submissions. Experienced commercial court judge had well in mind, as we've seen from the pleadings, the case advanced by the bank on breach and causation. It had our submissions in mind, and the judge made a series of findings which your lordships will have read, but she does accurately and carefully summarise the contentions that were made. She highlights the bank's case, for instance, paragraph 45, and likewise 55 and 56. She highlights relevant parts of the argument. And indeed, one can see at paragraph 61, she addresses this issue. There was an issue between us as to the stage at which the counterfactual was raised, but you'll see in 61, she said, in my view, the key point for this purpose is in the bank's case, BP was the lawful holder of the bill of lading at the time, yet the claimant nevertheless accepts that it is reasonable to assume the bank would have been involved and would have sought to give instructions to owners. So that's the premise on which she proceeded. So that shows that she was considering the very issue that we are.
Sorry, just which paragraph are you on?
Paragraph 61, my lord. Page 56 of the. I think your lordship's got it loose. But, the last 1, 2, 3, 5 lines of that paragraph.
Yes, thank you.
And just to reiterate, given I think what my learned friend's first point was that she failed to identify the breach, just repeat that of course she identified exactly the alleged breach at the bottom of paragraph 62. So that is the basis on which she proceeded, and as I said, she found against the bank on that. You'll have seen her consideration of the evidence. At 101 she expresses the view that she needs to approach Miss Bodnier's evidence with some caution. That evidence was about what she would have done if the bank had been asked to permit delivery, and then she reaches her conclusions in obviously paragraphs 119 to 122. If I might just highlight to the court, if one looks at paragraph 121 subparagraph 3, she finds on the evidence that if the claimant had been aware or told discharge was to be made by STSSO, the claimant would not have halted discharge and have carried out investigations into Gulf. Now, that's relevant because that feeds back into the point made by Mr. Russell in his closing argument and reflected in the written arguments, that on this counterfactual, if the bank had been told, it would have triggered an investigation. And what she says, no, that's not what would have happened. The court may cross-reference the closings, paragraph 47, and the submissions at supplementary bundle 526. What that serves to show is that she had in mind the very counterfactual that was being advanced by the bank, i.e., if we'd been told by owners that they weren't going to discharge without a bill of lading, it would have triggered an investigation, and that's why the cargo would have stayed on the vessel. And it's that premise that being communicated or contacted by the owners to say we want the bills of lading would have triggered an investigation is the one that the court rejected. That's the factual. That's the facts that the bank sought her to. The factual find they sought to make, but she didn't. So, in our submission, when one looks at it in that way, and it may be the the workload on judges is significant. The bench will know, but maybe when one reads the judgment, the precise position isn't as clear as it might be, but it's evident when you look at it in the context of what was put to the court and the arguments, how they were framed, exactly what she was answering. It's the very question that she was asked to answer by the bank. So we submit that there is quite simply no error of law in this case. It turns on the facts, and she made the relevant findings against the bank.
And you say to you, well, that doesn't undermine the whole edifice of trade financing security, because in other cases, since it's conceded that if express consent is given, it will destroy the security interest, those who are involved won't always be in a position where the court will be able to find that if asked, they would have said yes and done nothing else. They might have said yes and taken some alternative security or something of that nature.
Indeed. It may, I don't think it's overstating it, but the contrary case from the bank is effectively the owner's therefore a guarantee, providing some form of guarantee, which is plainly not the case. Even if you expressly authorise discharge in these circumstances, it doesn't matter, you're still liable to us. That would be a surprising conclusion. It certainly doesn't undermine, in our submission, trade finance. So it's, as I said at the outset, in our submission, this is a fact-specific case, and it turns on the.
But it's a causation case that could be taken. It's a causation case that could be taken in every case, and it would only be fact-specific because the bank would have to be able to say, no, we wouldn't have just said yes.
Yes, precisely.
And if they would have just said yes, and that is the normal position, well then they're not getting the security they thought they were getting by taking a bill of lading.
But in this scenario, the posits, the bank, the owners have said we need the bills of lading, and the bank are saying no, you can do it without the bills of lading.
But that's the hypothetical, because it arises on a causation. We're not looking at that actually happening every time. We're looking at the normal case where the owner just says yes, I'll discharge against the LOI and doesn't raise the question. But in every case, such case, this causation point would arise and would involve the bank essentially losing what it thought was its security interest, unless it was in a position to say, well, if asked, we wouldn't have said yes.
Just to look at the matter from a different angle, I've outlined already the bank's key factual premise that the cargo absent breach wouldn't have stayed on board for, it seems, 3 months or more. Nowhere actually in its submissions, either here or below, have the bank actually said on this hypothetical how long the cargo would have been on board the vessel, but it seems at least 3 months, if not more. And if that's the finding for which they contend, I'm bound to say that there's no finding in the judgment to that effect. So, to I think your Lordship's point, that if you're not happy with the conclusions the judge reached, there's no finding in the judgment upon the basis of which they could say that the order made judgment should be overturned. It would seem to us that remission would be necessary. What you do, however, have in that circumstance is the following. As I hope I've shown the court, there's an express rejection by the judge of what we described as this alternative reality. The cargo had just sat on the vessel. She's rejected that. And that was in the light of all of the arguments. And what we submit is clear beyond doubt, is that the gravamen of her finding as to what would have happened had the respondent required the bill of lading to be produced is absolutely plain. Whether the bill of lading was physically produced or there was consent from the bank the same thing would have happened. The cargo would have been discharged in just the same way as it was. If you look at her judgment, that is the gravamen of it. And we do submit that there's no reason whatsoever to believe that even if you consider the counterfactual is not accurate, but that her conclusion would have been any different to that which she actually reached. So we do submit that when one reads this fairly in light of the evidence and the findings, that is the conclusion which the judge would have reached, that the result would have been the same in any event. And I just do mention in that context that amongst the points made in paragraph 57(3) was the submission we made that if the bill of lading was required to be used, the factual outcome would have been the same. That was something again in the judge's mind.
Sorry, I keep missing the references.
So 57(3), my lord.
57(3), thank you.
On page 55. So she had that well in mind as well. So in our submission, that is why the appeal on ground 2 must fail. We do submit that she adopted the approach she was invited to. She made factual findings on the basis of that approach which are fatal to the claim. We submit that the approach was indeed the right one, and as I've said, if not, the bank only has itself to blame, but there's certainly no error of law in the judgment on the basis of which this court should overturn it. I just wanted at this juncture to draw your attention to a recent judgment in the Singapore court. We were wondering how long it might take for reference to be made to the court's decision below. I hope you will have a supplementary bundle of authorities. It says with some...
No.
Right.
No. And mine come in 2 volumes.
So, sorry, do you have a second? Apologies, it's a second volume. Then
Oh yes, we have 2 volumes of authorities.
Oh.
I'm sorry. I thought there was a meaning.
No.
Should have had a new one overnight, which we have not.
No, I think the parties have been well behaved in this case, unlike many. So I hope that will have at tab 4
Yes.
a judgment of the High Court of the Republic of Singapore. It concerns a vessel called the Maersk Princess, and it arises out of a failure of a company called HLT. Now, I'm not sure I need to take the court necessarily to the facts of the case. What happened in that case is factually different, because the finance was sought from the bank after discharge had taken place without production of the bill of lading. And in a way, a number of these cases, an arrangement was put in place which catered for that. So an argument was run, which we don't suggest is necessarily relevant to this case, but that because that finance was put in place ex post facto, that was consent to discharge without bills of lading. That was one of the issues, and it's a summary judgment appeal, and amongst other things, the court considered that was a triable issue. But we refer the court to it because there is a consideration in the judgment of both this case and the case called Anika, which was judgment of Andrew Baker's in 2021, and that starts at paragraphs 33 and following. I'm in the court's hand as to whether it would want to read that now. It's a longish section.
So you want us to read from 33 to
247 is the relevant part of the judgment.
What do you say we get out of it?
Well, what I was going to draw to the court's attention, it may be sufficient for present purposes, is a summary at paragraph 46. And I think it's appropriate the court has at its disposal the comments on the case and so forth from other judicial sources. I pause to note the position at law is unclear as to how the test of causation should be applied. The approach taken in the Nika and the Sienna appears to suggest the court should consider whether the misdelivery is the effective or approximate cause of the loss. On this view, even if the carrier had misdelivered, the misdelivery would not be the effective approximate cause if the claimant would not have insisted on discharge against presentation of bills of lading in any event. So I'd simply draw your attention to how it's been viewed in Singapore. Now, at the risk of going back over ground we may have already covered, my discussion with Lord Justice Popplewell indicated that the bank's position may now be, and we see this in the context of the discussion about the 6 off-takers. They now say even if they've been delivered to those 6 authorised, that would be no defence. So there seems to be potentially a shift of position that the bank's consent to discharge without a bill of lading wouldn't be a defence. Now, I'm not quite sure where the bank stands on that. Mr. Russell seemed to accept, when asked by your lordship, that it would be a defence, but some of his submissions suggested that's not the position. He certainly hasn't outlined the limits of the consent defence for which he would contend. But as I've already submitted, it seems to us to be the inevitable consequence of the argument the bank had to run to get around the factual findings of the court. And indeed, as I've submitted, it does seem to us to lead to the situation where there is never a defence of consent, effectively some form of guarantee provided by owners, which we submit can't be right. And indeed, we submit that that's firstly no answer to the causation analysis, i.e. misdelivery would not be the effective cause if the claimant would not have insisted on discharge in any event. But secondly, we had understood it to be the case that communicated consent was acknowledged as being a defence. And I think this, as I understand it, comes in at my learned friend's, I think, 6th point, where he suggested that even on the hypothetical, the court failed to appreciate there was no defence to a claim. Now, I'm bound to say that that's certainly not a point taken before the judge. You've seen the submissions as I've explained them, but if it is, then we submit it's obviously wrong. There's a passage in the authorities from Aikins, which is in tab 20 of the authorities bundle, page 298. Particularly at paragraph 5.49, it reads, as discussed above, it's a breach of contract, usually conversion of the carrier to deliver the goods other than presentation of the bill of lading. It follows that to defeat a claim for misdelivery with the holder, the carrier must establish that the holder evinced an intention to waive the contractual obligation only to deliver against the bill of lading, whether what is required is analysed as a variation of contract, a waiver of compliance with a term of the contract or equitable estoppel arising from an intention by the holder. It will usually be necessary for the carrier to demonstrate some communication of the holder to the carrier. And just at the bottom of the page,
Always be necessary.
I apologise, my lady. We'll see that in other contexts may not be accurate, but we'll come to that in a moment. And then you'll see right at the bottom of the page, it's inherently improbable that the holder of the bill of lading will consent to acquiesce in delivery of the cargo without the production of the bill of lading in the abstract. The few cases in which arguments to consent have succeeded involve the holder expressly or impliedly authorising delivery without the bill of lading to a particular recipient. Now, just pausing there, we submit that in the context of what appears to be the argument from Mr. Russell, that the counterfactual itself doesn't give rise to a defence. In our submission, it plainly does. The counterfactual is that the bank's approached, owners say we want the bills of lading, and they give their consent to discharge without those bills of lading. In our submission, that plainly falls within each of the requirements set out in that particular passage. In terms of communication on this hypothesis, there is communication submitted to Lord Justice Popplewell. Whether it's direct or it's through somebody else doesn't matter. But ultimately, that consent's been communicated, and we submit that if that is the point that's raised, then it's a bad one for that reason. It is, as I've said, something we thought was common ground, and you'll see a section on acquiescence in the skeleton at paragraphs 84.2. I won't turn it up, but maybe Mr. Russell will let us know what his position is in due course. So we do make that submission, and indeed, as I just indicated, the position is certainly more nuanced than there being a requirement for communication. It in our submission doesn't necessarily reflect the full picture, and there are a small number of authorities I might just take you to, because they're relevant potentially to this issue depending on how you view the case, but also in the context of the ground one of the respondent's notice and the position of BP, which we'll come to maybe after lunch adjournment. But in this context, if we might start by looking at an extract from the latest version of Voyage Charters, which is at tab 5 of volume 2 of the authorities. And I believe it's at page 76, paragraph 18.171. And subparagraph 1 is the passage to which I direct the court to. And I wonder if I could invite you to read that through to the end of the discussion of the Finbank case on the following page.
And the Nika was the case that was also referred to in Singapore.
Correct. It was. We'll come to look at it briefly in a moment. As you'll see, Miley, I'm not sure if you then read footnote 411, which picks up on the comment I made about the decision. Sorry, the commentary in Aitkins. It says it's in relation to evidence of acquiescence, and it picks up Aitkins' reference there. And again, if I might ask the court to read that. And I really highlight this, and we'll go through it simply because the case may be put in different ways against us, but in our submission there is a broader picture than simply direct communication of consent. Of course, we say that is on the counterfactual, that is the position. We also have this issue of authority and delivery under authority and so forth, and that is.
I have myself a little difficulty with authority being sufficient. It's a breach to deliver to the person who is entitled to delivery without production of the bills. So the fact that the receiver has been authorised by the holder to take delivery without presentation of the bills, it's neither here nor there, is it? If there's no communication.
Well,
and I know that's what's suggested in the footnote, but I have some difficulty with that.
Well, my lord, as I said, we don't believe we get into it.
I understand.
But
I understand that. You say it doesn't matter for you.
Indeed.
You can have communication indirectly, but it's got to be communication to the owner.
My lord, and that's the basis upon which we submit the judge found it. And as I said, if it's accepted, indirect communication is sufficient. If that's the point that's taken against us, then so be it. I mean, the Nika is in the bundle. There was a lively debate between us below about the position. My learned friend said, well, it's only a question of it's breach but no loss situation. Andrew Baker felt that the position wasn't clear, but it may be that's a debate that we don't need or want to get into at this stage if the premises I've advanced are in principle accurate. What I would, I think, just take your court to again, so that it has the full picture, is another Singapore decision in the STI Orchard, and that's at tab 3 of the additional authorities. Now, this is another case arising out of failure of HLT in Singapore, in fertile territory for the lawyers, if nothing else. And if I might just ask the court to read the first paragraph 2 of the head note, just to summarise the very basic facts. Again, which isn't evident from that short description, but in this case, the consent, again, is different from our factual scenario, in that there was a reliance on the ex post facto provision of a trust loan receipt. For your note, you'll find that at paragraph 74. But that's not what I want to take the case, sorry, what I want to refer your Lordship to, but rather there's a summary of principles, synthesis of the principles in relation to consent at page 38. It starts on page 37, and that just sets the scene. The court says that it should be noted the defence...
Sorry, what paragraph is that?
69, and the key ones are 70 and 71.
Thank you.
And 2 points we would make in that context. It's a summary of synthesis of the approaches that court sees it. We do submit, and it's not our case, but we highlight this in case court sees the judgment differently. But there is an issue as to whether, as per B, acquiescence in the form of non-communicating consent could be sufficient to avoid liability. And it's apropos of what might happen should you not be with us on this appeal. But we also note in paragraph 71, which is directly relevant to a point that the bank has made on a number of occasions. We weren't bill of lading holder at the time, therefore what we did was irrelevant. In our submission, the court's reaction there is absolutely right. Consent covers instructions emanating from the person who was not the bill of lading, sorry, not the holder of the bill of ladings at the time of delivery, but subsequently became holder. As a matter of principle, I see no reason why a person should be allowed to resile from his earlier instructions that led to ship owner's breach. And we submit, if that's a point that the bank pursues, it's a bad one for that reason. And I think intuitively would submit that must be the case. In any event, we submit we're in the happy position where we effectively fall into subparagraphs A or C or both, and B is not a matter that the court needs to trouble itself with at this stage. But as I've said, drawing your attention to that, not because I think our case critically depends on it, but we do feel the court may wish to have the wider purview, even if it considers these cases not to be directly relevant. They may have an impact, as I've said, should you not be with us, on what you do with the case going forward. But that gives, I hope, the court a wider overview of the position. Unless I can assist the court any further, that is our case on ground 2. And I was therefore intending to turn to the respondent's notice. Oops. Now, I think we had a brief summary of the response to the first ground of the respondent's notice yesterday. Our position is is this, and this arises out of the position adopted by the bank that it wasn't a holder of the bill at the time of discharge, and therefore its own consent is irrelevant. So that's the origin of the argument. I noted the objection my learned friend raised, and I think would indicate it wasn't impressed with that, so I will not address that. It's dealt with in our skeleton in any event. But looking at the merits, in our submission, the notion of bank's consent is not relevant is wrong for the reason I've given, but even if one proceeds on that basis, the scenario here is that BP in fact remained the lawful holder of the bill of lading until August, and certainly at the time of discharge. Our submission, even if you find against us on the other grounds of appeal, that causes a problem for the bank. And we say that is for a simple reason, is that there is no breach of any contract contained or evidenced by the bill of lading if, as we say, it is the case, BP consented to discharge delivery without the bill of lading. Now, I've covered some of the ground in terms of the approach to consent, communicated consent, so I'm not going to repeat that. I've indicated we submit the position is probably broader, but what we do submit on this appeal, reflecting our case below, is that whatever the approach you take, it is clear that BP did communicate its instructions or agreement to the ship owner that goods should be discharged without the bills of lading. And in accordance with the authorities looked at, we submit that gives a defence to a claim for misdelivery.
Discharged where?
As it was. Sorry, discharged.
Discharged in Soha,
yes.
Not discharging for Jan.
No, in Soha. And we say it's simply the same application of the same principle, same as any other case where you have communication from one contractual party to another not requiring contractual performance. So that's in outline how we say the position is to be analysed. There's two or three interrelated aspects which, to be clear, are independent of each other. They are summarised so that the court has a reference point in paragraphs 66 and following of our skeleton argument, which is at the core bundling page 179. The first step, and much by way of background to the novation, we do submit and did submit below that BP communicated with owners that it required discharge of the finance cargo to be made without the bill of lading. This is the point my learned friend focused on, or his lordship focused on my learned friend. It's a communication of the 12th of March, which your lordship looked at. And we accept that documentation is not the clearest, but we'd ask you to read it with the master's statement at paragraphs 18 and 19, which is supplementary bundle page 334.
But taking up your answer to my recent question, we should read that as being an instruction to discharge at Soha, should we?
Well, that is probably a fair observation at that stage, yes. As I said,
Sorry, what?
That would have been the instruction.
That is how we should interpret the communications of the 12th of March, even though the actual discharge instruction that was given
Sorry, my lord.
was to anchor at Fujara and await for the orders.
At Fujara, I accept that, my lord. And that's why we emphasise it's not an essential part of our argument. It may not be the best.
Well, you said each of these is sufficient in itself. It's not.
Well, my lord, I acknowledge that. If I might move on to the nub of the argument.
Yes.
Then, we submit that what one does see, secondly, is that irrespective of view on the first issue, the fact and the terms of the novation agreement, as we say, objectively interpreted, communicated BP's instructions and consent to owners discharging, delivering the finance cargo without the production of the bill of lading upon Gulf's instructions to do so. Now, you will have seen the novation and its terms. By clause 1.2, Gulf has become party to the charter party and is entitled to all the rights and benefits. Model is tab 24, page 83. Just referred to the provisions in paragraph 1.2, and we submit that in those circumstances, what BP were agreeing with owners was that Gulf should become charter on terms which, as it had done with BP, when BP was the charterer, obliged owners to discharge without production of a bill of lading on charter's instructions. So we submit that when one views that objectively, it's communicating BP's consent, we say continuing consent, and indeed instructions to discharge if required by Gulf to do so. And of course, on this analysis, in our submission, BP is now the bill of lading holder. That is the finding that the court makes. So it's not acting qua charterer anymore. Its only relevant capacity is as bill of lading, bill of lading holder. And viewed in this manner in our submission, it's the case where, on the hypothesis that the banks succeed on grounds 1 and 2, the bill of lading holder is a signatory to a contract which obliges the ship owner to discharge without production of the bill of lading being instructed to do so. And that is communicating consent, authorisation to that to take place. The third...
Sorry, you've gone, I think, a little too fast there. You say BP is now the bill of lading holder. It always has been. The hypothesis on which this argument arises is that from the date of novation, that is when it ceases to be charterer, there is a contract of carriage contained in or evidenced by the bill. Is that the premise that we're working on for the purposes of this respondent's notice point?
My Lord, that is the premise. It would, in our submission, also be the case if...
Well, that's the premise. So then you say that in relation to what is said in an agreement which deals with the charter party rights, BP is acting in its capacity as bill of lading holder in relation to the rights which are about to spring up under the bill of lading contract.
Well, that is what one takes from it, is that...
I mean, that is the effect of the submission.
It is. It is.
And why should one treat BP as acting in that capacity vis-a-vis the bill of lading contract in what it is saying in relation to charter party rights?
Because this is a prospective consent. It's saying, in the future, we authorise you to do this. In the future, BP would and could only be acting as, in its role as bill of lading holder. So by definition, it is consenting as bill of lading holder to those activities, to that action being undertaken.
Well, it isn't the bill of lading holder. It isn't the bill of lading holder in the sense of being party to a contract of carriage on the terms of the bill of lading, unless and until the novation agreement itself takes effect. two are contemporaneous.
Of course.
And what it is doing in agreeing the novation agreement, it's doing qua charter, isn't it?
Well, in our submission, the consent or permission which is going forward can only be given, if you like, in its capacity as a future bill of lading holder. So in the future you can do this. In the future we will only be bill of lading holders. We'll only be interested in the cargo in that capacity, and therefore
And we will have rights and obligations under the bill of lading contract, and they require you to discharge it for JARA.
well, that as we all.
That's the point it's one of the points you've made. So,
But the point, my lord, is that of course.
was it a variation of that contract?
Indeed, and they're waiving
So
the.
when NFBP had endorsed it on to another party, the contract in the bill of lading would no longer be one to discharge it for JARA. Is that your submission?
Well, this is the point, and one of the points one of the friend makes about the waiver. He says in response, if there was a waiver by BP, it doesn't bind us as subsequent bill of lading holders. And
I think it's a logically anterior argument that nothing that's being said in the novation agreement by BP was qua holder of the bill of lading.
Well, in our submission, when one says, well, actually, you may do this in future, and you understand that in future your sole position or your sole role capacity will be as bill of lading holder, it must be given in that capacity. In the same breath that we're saying we're ending our role as charterer, moving forward you're entitled to do this. Moving forward, the only role that we will have is as bill of lading holder. Therefore, by definition, we must be giving permission, consent in that capacity. And of course, subsequent endorsement came after discharge, and the straightforward point we make is, given this, at the time of discharge, the bill of lading holder consented to what was taking place, and therefore there's no breach. So the question that then simply arises whether there was a waiver which the bank is able to say doesn't bind or affect it, which is Mr. Russell's second point. Maybe given the time, I can come back to that issue briefly after the adjournment. I think we're doing well on time.
I think we're doing well, and I think this is a convenient moment. Mr. Russell, you?
But Lily, can I just draw the court's attention to one point very, very briefly, just so that there's no misunderstanding in relation to some of the arguments. This is not a criticism of our friend at all. Mm-hmm. It's simply to remind the court that the bill of lading, in fact, didn't require delivery at Fujairah. The bill of lading was Fujairah for orders. So it's not simply a bill that requires delivery at Fujairah. It's been said a number of times by a number of people that required delivery at Fujairah. That's certainly not our interpretation of the bill. It's not uncommon when the bill is issued, the discharge port hasn't been determined for a bill to provide a place for orders. It may be a port where discharge could take place, or it may be...
Thank you. I had overlooked that. Thank you.
Yes.
I'm very grateful for that clarification, and we'll recommence at 2 o'clock.